Good afternoon, everyone. Thank you very much for coming to today's CCPL seminar. And we have a very interesting topic today. We're looking at the system of pardons in Malaysia in the context of this very interesting individual, Anwar Ibrahim. And it's always nice to reflect on how this system of pardons compares to ours in Hong Kong. We really don't have a system of pardons. Basically, you petition to the chief executive, and the chief executive decides. So it'll be very interesting to hear about the Malaysian system. Our speaker, of course, is Dr. Daniel Pascoe, who's an assistant professor in the School of Law, City University of Hong Kong, where he teaches criminal law. And as I understand, his presentation today is based on his doctorate studies, which he did at Oxford University. So please join me in welcoming Dr. Pascoe.
Thanks, Simon, for the introduction. So thanks also for the invitation to come and speak here at HKU. I last spoke here at the CCPL's Death Penalty Conference, which was in 2013, October of 2013, and it's a pleasure to cross the harbour to visit. As Simon said, I am assistant professor, not associate professor, as advertised on the poster. So if you'd like to see someone tenured speaking, maybe the next seminar will be for you. But today I'm going to talk about the Malaysian system of royal pardons, and in particular the case of Anwar Ibrahim, who was the former Deputy Prime Minister of Malaysia. And Anwar Ibrahim's petition for pardon was rejected by the young di-Pertuan Agong, who was the Malaysian king, in March 2015. Now, my earlier research on Malaysia's system of pardons, carried out through archival and elite interview-based fieldwork, took place in Kuala Lumpur in 2011 and 2012. And this earlier research has helped me to formulate some hypotheses as to why the young di-Pertuan Agong rejected Anwar's petition in March of this year. So many of you will know about Anwar's case and the background to Anwar's case. Anwar served as Malaysia's Deputy Prime Minister from 1993 to 1998. He was Finance Minister from 1991 to 1998. And he was a Member of Parliament for UMNO, the United Malays National Organisation. And he'd been groomed as the eventual successor to Dr. Mahathir Mohamad, who was Malaysia's Prime Minister at the time. But then in 1998, following a political split with Mahathir, Anwar was removed from his posts, and he was charged and convicted for abuse of his ministerial office and also for sodomy with his family's driver. Sodomy remains illegal in Malaysia. Now, internationally, these charges and the convictions were denounced as coming about as the result of political interference in the criminal justice system and as an attempt to end Anwar's political career. He was sentenced to 15 years imprisonment, and he served all 6 years of the corruption charge. But then in 2004, he was released when the Malaysian Federal Court, the highest appeal court in Malaysia, overturned his sodomy conviction. Meanwhile, following these initial allegations, Anwar's wife, Dr. Wan Aziza Wan Ismail, founded a new political party in 1999 called Parti Keadilan Rakyat, which is the now leading opposition party in Malaysia, and it was the one that Anwar was then to head and to lead when his ban from politics expired. So from 2008 to 2015, Anwar served as Malaysia's official opposition leader. However, in 2008, Anwar was again arrested for sodomy, and he was charged with the sodomy of a male aide of his, a charge that was again criticised internationally as coming about due to political interference in the criminal justice system. But he was acquitted by Malaysia's High Court in January 2012 in time to contest the May 2013 general election, which was fairly close run, but he lost to UMNO with Parti Keadilan Rakyat. But then in March 2014, Anwar's acquittal was overturned by the Court of Appeal, and the Court of Appeal imposed on him a 5-year prison sentence. Anwar's final avenue of regular judicial appeal was to the Federal Court, which, as I mentioned, was Malaysia's highest appeal court, which confirmed the Court of Appeal's decision in February 2015, although he has filed a couple of judicial reviews since then. So due to his conviction, Anwar is banned from politics in Malaysia for 10 years. That's 5 years of imprisonment and 5 years after his release in the future. And his wife, Wan Azizah Ismail, in May of this year, won a by-election for his former seat in Penang. Anwar himself remains incarcerated in the Sungai Buloh prison in Selangor, which is on the outskirts of Kuala Lumpur, where his health is said to be deteriorating. And many of his supporters, including his family, who submitted the petition on his behalf, had initially pinned their hopes on a royal pardon, which, as mentioned, was submitted in February 2015, but then rejected in March 2015. So in my paper, I argue that due to a number of systemic features of the Malaysian royal pardons process, these mean that the young di-Pertuan Agong's rejection of Anwar's petition came as no real surprise to watchers of Malaysian politics. Before I begin to analyse my purported explanations for the Agong's rejection of Anwar's petition, just a short comment about methodology. Although there exists substantial literature already on the powers and procedures of the Malaysian Pardons Boards, and also literature on the various state and federal rulers who exercise that power to pardon, these studies tend to look at pardon from a doctrinal or textual perspective, often in the context of larger studies concerning the mandatory death penalty for drugs and firearms offences, or perhaps the powers and immunities of the Malay monarchy. In order to expand this literature and to draw conclusions as to what exactly goes on within the meetings of the Malaysian Pardons Boards, qualitative empirical research was needed rather than just doctrinal analysis. So as such, I attempted to systematically gather information on the whole population of prisoners who benefited from royal pardons in Malaysia's recent history, and also to interview a few people, lawyers, judges, politicians and NGO staff in Kuala Lumpur, in order to get some sense of the way in which these pardon decisions were made within the Pardons Boards. And I assume that it's not possible to observe board proceedings firsthand, nor to see records of the proceedings in Anwar's case or other cases. So after conducting the research, the empirical research, and reviewing the previous academic literature, I can make 3 tentative conclusions on the basis of the available evidence as to why the Agong has rejected Anwar's petition in March of this year. And the 3 plausible hypotheses are the following, or they relate to the following factors. First of all, the previous history of Malaysian royal pardon grants. Secondly, the overt political influence on Pardons Board decision-making. And third, the historical role of the Malay monarchy. Before I outline my conclusions, these 3 conclusions, I'll provide some background on the Malaysian system of royal pardons itself. So in Malaysia, the royal prerogative to grant pardon can be used either to reduce a death sentence to something less than death. It can be used to reduce the length of the prison term, or it can be used to release the petitioner altogether from prison. And this reduction, this commutation, can be initiated in one of 3 ways. First of all, you can submit a petition to the relevant state or federal pardons board, which then advises the political leader to exercise their discretion. Second, all death sentences are automatically considered for clemency once they're finalised by the courts. And third, each prisoner serving a long-term sentence of imprisonment is automatically considered for release every 4 years, or when the Pardons Board next meets, whichever comes later. And in terms of composition, each of the Pardons Boards comprises the Federal Attorney General, Malaysia's Federal Attorney General, or the delegate of the Attorney General, the relevant State Chief Minister, and up to 3 appointed members of the public. So together there are 16 different Pardons Boards, Federal and State Pardons Boards, and they make recommendations to the Malay hereditary rulers within 9 states, to the 4 appointed state governors in states that don't have a ruler or a sultan, and to the Malaysian king, the young di-Pertuan Agong, in federal, military and security cases. Now the decision makers, the rulers, the governors and the Malaysian king, they're not obliged to follow the board's recommendations, but they're known to do so in a majority of cases, particularly when they preside over the meetings as chairman of the Pardons Board, per se. And finally, the materials before each of the board has some effect on the nature of the decision. So the materials include the petitioner's petition, the prisoner's petition, which outlines the reasons why the pardon should be granted. Second, reports from the police, from the narcotics board, from psychologists, and from the prisons department on the prisoner. And third, the written report of the Federal Attorney General. And in death penalty cases, there's the additional requirement that the trial, the evidence notes from the trial, as well as recommendations from the trial and appeal judges, are put before the board. So the first of my explanations, the first of my hypotheses, is that over the past 4 decades, none of the relevant decision makers ever appear to have issued a pardon on the grounds of factual innocence leading to a wrongful conviction, which were the grounds that Anwar and his family argued before, or submitted within their petition before the Federal Pardons Board. While pardon grants or board recommendations are obviously not subject to the doctrine of judicial precedent, the historical context which we can look at provides some indication of the way that the current cases are dealt with within these pardons boards. Now, although the reasons for royal pardon grants or rejections are not often made public, it's possible to speculate on and narrow down the range of factors that may have proved influential across a variety of cases, based on empirical research through looking at media reports, through looking at the secondary literature, and conducting interviews with people in Kuala Lumpur. So generally, scholars and commentators, including journalists, have seen non-legal factors of being the greatest importance to the decision-making of the pardons boards and of the Malay monarchy. So the types of non-legal factors that are relevant include the country of origin of a foreign prisoner's of a foreign prisoner, so as to maintain good international relations with that country, together with the public service, the previous public service of the prisoner, and the political connections of the prisoner. Second, there have been a number of cases where retributive justifications for royal pardon appear to have been decisive. So these sorts of factors include the youth of the prisoner, cases where a complete or a partial defence was argued in court by the lawyers but didn't succeed in the court, where there have been procedural irregularities, or also where some other type of pressing criteria emerges for commutation during the trial. And then finally, third and finally, rehabilitation also appears to be important before the Malaysian Pardons Boards. In the absence of a separate body for the task, each of the Pardons Boards also functions as a parole board, because there's no such thing as a separate parole board in Malaysia. Many prisoners in lower profile unreported cases have been awarded pardon or commutation where the prisoner showed remorse, had repented and apologised, and promised good behaviour and not to repeat the offence, to quote a New Straits Times report. And as I noted earlier, each prisoner serving a long-term sentence is automatically considered for pardon every 4 years by the ruler, Agong, or the governor, and they have the right to petition that decision maker for pardon every 2 years. So the result is, say, for a prisoner serving a life sentence or a natural life sentence, the longer the period that you spend in prison, the more likely you are to be able to satisfy some of the criteria for royal pardon, and also the more chances you have to petition for royal pardon. Now, in my paper, I go into quite a bit more detail as to my empirical findings on royal pardon grants from 1975 onwards. But for present importance, it suffices to say that no petitioners thus far appear to have been successful on the basis of possible factual innocence for the offence, as the written arguments put forward on behalf of Anwar presumably suggested. Although the contents of Anwar's petition weren't divulged to the media, nor was I able personally to obtain Anwar's petition after emailing his lawyers, a quote from Anwar's second daughter, Nurul Nuha, is telling. And she said, "The court may have passed a guilty verdict, but our father is innocent. Therefore, we're submitting the petition based on Article 42 of the Federal Constitution." Likewise, for Anwar's eldest daughter, Nurul Izzah, her hope was that through the pardon, the Agong would right the wrong, especially in the miscarriage of justice that has taken place. So you can see that that Anwar's family had argued for pardon not on the basis of mitigating circumstances, but on the basis of wrongful conviction. So all of these factors, the successful factors, appear to have been either mitigating factors or at most procedural irregularities rather than completely exculpatory factors such as wrongful conviction on the basis of fabricated evidence, which is what Anwar's family was alleging. Of course, it needs to be acknowledged that Anwar does exhibit one of the key mitigating factors that's been used in previous cases, and that is his previous service as an UMNO politician. We don't know if this was discussed in the relevant Federal Pardons Board meeting, but what we do know is that previous pardons awarded to serving politicians have invariably involved current members of the ruling party, rather than former members of the ruling party. The only exception to this is Democratic Action Party MP and the current joint opposition leader Lim Kit Siang, who was awarded a pardon in 1969 after contravening election laws. As it was, the Malaysian king rejected Anwar's petition, and he found that no requisite mitigating circumstances could be found in Anwar's case. And tellingly, that factual innocence never appears to have been considered by the Malaysian Pardons Boards in the past was one reason for Anwar's initial reluctance to submit a petition in the first place. So he refused to submit a petition, and an application was eventually put in by his family because Anwar himself petitioning the Agong would arguably paint an impression of guilt on him. So implicitly, prisoners applying for pardon admit their guilt for the offence. Prisoners applying for pardon admit their guilt for the offence. So that's my first hypothesis. My second hypothesis, the second plausible hypothesis explaining the rejection of Anwar's petition, is to do with the overt political influence on the Pardons Board, along with the nature of the materials considered by Pardons Board members. Now, the starting point here is that despite the official position, the establishment position, being that the Pardons Boards deliver politically impartial advice and that the federal government has no say in the power of pardon, to quote Hashim, the political representatives on the Pardons Board, consisting of the Federal Attorney General, the local Chief Minister, as well as perhaps politically sympathetic lay members are usually in a position to make a recommendation that suits the elected government's agenda. Whether or not this final decision maker, the Agong, the governor, or the Sultan, whether they act on that recommendation or not is irrelevant for this second explanation, because the very fact that a negative recommendation tends to be made increases the chance that the petition will be rejected. So the significance for Anwar's case is that, as I mentioned earlier, both within Malaysia and outside of Malaysia, it's widely suspected that Anwar's conviction was a politically motivated attempt by the UMNO leadership to end his political career. Although we can't be sure, in the absence of first-hand testimony, if Malaysia's federal government wanted Anwar's royal pardon petition to be rejected, through the Federal Attorney General and the political members on the Pardons Board, they would have been able to achieve such a consensus in order to make that recommendation to the Malaysian King. And here the role of the Federal Attorney General is important, as I'll go on to explain. So the Malaysian Constitution provides that members of the Pardons Boards shall consider any written opinion which the Attorney General may have delivered thereon. And it's also the Attorney General's report that is considered first in the meeting before any other report. It's therefore of no great surprise that three of the interview sources, three of the people who are interviewed, suggested that it's the Federal Attorney General's written and oral submissions that are seen as having the greatest influence over the final decision of the Pardons Board. As one of these interviewees noted, unlike the other parties who submit documents to the board, so unlike the petitioner himself, unlike the trial and appeal judges, say in a death penalty case, and unlike the prison governors or psychologists, the Attorney General is the only author of these reports who's physically present at the meeting and can therefore defend his position before the board. Now there are two key reasons why the Attorney General's written and oral submissions before the board are likely to reflect a negative view towards the petitioner's chances of succeeding, of getting a petition for pardon or commutation granted. First is the concurrent role of the Federal Attorney General as Malaysia's chief prosecutor, and second is the Federal Attorney General's historical lack of independence from Malaysia's elected government. As for the former role, as the chief prosecutor, we could ask ourselves, why would the Federal Attorney General recommend pardon if the state has already put significant resources into the prosecution of the case, other than perhaps for circumstances which arise well after the conviction itself? So that's the first one. The second issue regarding the Attorney General's independence, well, the appointment and dismissal process for the Federal Attorney General is done via Prime Ministerial recommendation, direct Prime Ministerial recommendation. So this makes it likely that the nominated person will carry out the bidding of the elected government. And in his own case, Anwar Ibrahim questioned the impartiality of the Attorney General who sat on his Pardons Board, and that was the former Attorney General Abdul Ghani Patel, by stating that Patel had a long-standing animosity towards him, stemming from Patel's role in prosecuting him during his original set of sodomy and corruption trials in the 1990s. So if this is true, and it's just a hypothesis, but if this is true, then it suggests that once the decision was made to prosecute Anwar a second time for sodomy, then the decision of the Federal Attorney General not to recommend pardon was already made, was already unequivocal. The only remaining task before the Pardons Board would be for the Federal Attorney General to convince the other members. Remember, the other members include a state chief minister, or in the federal case, the Minister for Federal Territories, but particularly to convince the three lay members of his view. Now, the lay members tend to be people of eminence, but it's unusual for them to be legally trained, and certainly the evidence we have suggests that they tend to follow the recommendations of the Attorney General. The third hypothesis I have concerns the nature and the status of the final decision maker on pardon in the federal jurisdiction of Malaysia. Now, as I previously described, the constitutional function of each of the pardons boards is to make a recommendation to the final decision maker, and that final decision maker can be one of the 9 state sultans, one of the 4 state governors, or Yang di-Pertuan Negeri, or the Agong, the Yang di-Pertuan Agong, which is the Malaysian king. So Talib has observed that even though the drafting of the Malaysian constitutional power to grant pardons was significantly influenced by the royal prerogative of mercy as exercised in the UK, the various state hereditary rulers, so the state sultans, had been exercising their traditional power to pardon well before the British colonial era began. So for hundreds of years they had been doing this. Raja Azlan Shah, who was a former Malaysian Chief Justice, and he was also the hereditary ruler of Perak state from 1984 until his death in 2014, had portrayed Malay sultans in a manner that suggested that they exercised clemency and pardon commensurate with being absolute monarchs as a show of power over their subjects and as a show of benevolence. And Raja Azlan Shah said the following: a Malay sultan during the Malacca period, 1402 to 1511 AD, held absolute power and his subjects gave him absolute loyalty. The sultan declared war, decided on life and death of his subjects, administered justice, and maintained law and order. Moreover, even the relatively recent pardons grants tend to be issued on the sultan's birthday and also on the first day of Ramadan, although it's unclear whether the festivities were the reason for the grant or they just affected the timing of the grant, where the grant was issued for other purposes. Interview sources also suggest that a number of the modern state rulers, including the sultans of Johor, Selangor and Perak, have demonstrated their independent discretion over constitutional matters of prerogative in recent years. And we can see this just, for example, 1 week ago, in the context of Malaysia's ongoing leadership crisis. All 9 of the state sultans recently issued a joint statement urging an investigation into the 1MDB scandal and, as I quote, appropriate stern action against all those who are found to be implicated. So what this indicates is that the state sultans may not be shy in intervening in what may be thought of as political matters. So consistent with this historical role of the sultans, interview and archival sources also suggested that the Pardons Board's dynamics will differ depending on whether the board is chaired by one of the sultans, one of the state hereditary rulers who've had this history over several hundred years of pardoning, or whether the board is chaired by one of the 4 appointed Yang di-Pertuan Negeri, which are the state governors, or whether it's chaired by the Yang di-Pertuan Agong, so the Malaysian king. The state governors, so the 4 state governors, these are people who are appointed on the recommendation of each state chief minister, and they're thought to demonstrate far less independence from government policy on matters of royal prerogative. Moreover, with significance for Anwar's case, the Yang di-Pertuan Agong himself holds a rotating throne, so it's rotated between the Malay sultans, and it was only created by the Federal Constitution in 1957, rather than being a standalone title stretching back hundreds of years. As such, we see that the Agong's independence decision-making independence on pardons in the federal, military and security cases that he deals with is the subject of quite a lot of academic and political debate. For example, when asked in Parliament about Anwar Ibrahim's petition for pardon, one of the ministers in the Prime Minister's department, Nancy Shukri, relayed the conventional view that the final decision lay with the Agong rather than with the Attorney General or the Board. On the other hand, Su and Urjitham have stated that the decision is exclusively his. However, the King will not see it as his function to take a different view from that advised. He's the head of state, not a political leader. Likewise, Bari has commented on the comparison between the sultans and the Agong. And Bari said the following: the rulers are more likely more able to assert their influence as they, unlike the young di-Pertuan Agong, practically reign for life. This enables the rulers to influence the administration of their states. So accordingly, the third of my three hypotheses is that Anwar's petition was rejected as the young di-Pertuan Agong has interpreted his constitutional role as to follow a presumably negative recommendation from the political executive who were acting as the Pardons Board. Now, if Anwar had been convicted in one of the 9 Malaysian states where there's a sultan rather than a governor, then conceivably he might have had more chance of being pardoned. But of course this assumes, and there's no guarantee, that each of the Malay sultans may have had more sympathy for Anwar than the Federal Attorney General or the young di-Pertuan Agong. Finally, one piece of further evidence for political control of the process is provided by the speed with which the board disposed of Anwar's petition. Now, in cases involving the state hereditary rulers, the sultans, it hasn't been unusual, unfortunately, for the petitioners, for cases, for petitioners to have waited 15 to 25 years to have their pardons considered. And as you can imagine, unless they're facing the death sentence or unless they're facing a natural life term, in most of these cases they tend to serve their prison terms by the time they come up for pardon, so they tend to be released already. And this is despite the fact that as chairman of the boards, the sultans received reports on the progress of the prisoner and their rehabilitation every 4 years. But there's no legal limit, no legal time limit within which the Agong, the governors, or the sultans must call a board meeting, or no time limit within which they must make a final decision on the pardon. So this is a matter entirely within their royal prerogative, and hence the very fact that Anwar's petition was submitted in February, it only took a few weeks to be rejected in March, suggests one of two things. Either that the Agong was quite keen to pardon Anwar, or more likely that there'd been a recommendation made from the political executive to reject Anwar's petition as soon as possible. And this was a recommendation that the young di-Pertuan Agong saw fit to follow within his constitutional role. So, by way of conclusion, each of these three hypotheses, each of these three explanations applies not only to Anwar's case, but also to all 16 of the Malaysian state and federal pardons boards in other cases. But the problem is that empirical testing of any one of these three factors is likely to prove difficult, if not impossible. Unlike the Malaysian courts, the proceedings of the pardons boards are not open to the public, and hence we can't make any first-hand observations on the decision-making process of the 5-member board. Moreover, absent any empirical data on the recommendations that the board makes themselves, we can't know whether or not the end result comes as a result of agreement between the chairman and the board, or whether the chairman, which is the sultan, the governor, or the Agong, has simply decided to take the matter of royal prerogative into his own hands. But despite these shortcomings, my conclusions on Anwar Ibrahim's case and on the pardons process in Malaysia generally are basically the conclusions I've reached on the basis of the best possible evidence available to the researcher. However raw and untested, any new hypotheses allowing for an incrementally better understanding of the opaque world of Malaysian pardons and negotiations appears to represent some measure of academic progress. Thank you.
Thank you very much, Nick. Very interesting and very clear. One question I had was, you mentioned that there are some ongoing judicial reviews. Are they judicial reviews of the board's decision, or are they judicial reviews?
I think Anwar has something like 16 present legal avenues he's pursuing, but the answer is it's for both.
Okay.
So he has launched a judicial review in relation to the rejection of his petition, and the basis for that is that the former Federal Attorney General, Patel, has this alleged long-standing animosity towards him, and therefore he wasn't impartial when he gives his advice. So that's the basis for his judicial review on the Pardons Board, and he's also launched a judicial review of the federal court decision which rejected his appeal against his conviction. So at least those two, plus a raft of other legal cases that he's pursuing.
And is that the final court? Is the federal court the final court?
Yeah.
I see. And how transparent is the judicial review? Will he be able to get access to all the information that you would need to properly challenge? Would he get access to the reasons? Would there be reasons?
Oh, the reasons for the Pardons Board?
Yeah.
No, I mean, this is the point. Previous Malaysian cases have established that because it's a matter of royal prerogative, you don't have to issue reasons, and the process is secret. So it's not really subject to judicial review.
Okay, so we've got some time for other questions or comments. Yeah, Juan.
How powerful is the monarchy, the Sultan? I guess whether they could make an independent decision very much depends on what other powers they may have. And another related question is, given the political crisis in Malaysia, is there a sign that they are grabbing powers from the state? I mean, there are many of them. They could get together to form powerful political groups.
Yeah, so they have this thing in Malaysia called the Council of Rulers, where all 9 of the sultans sit on this council, and I guess it could be perceived as a threat by the political executive. And there have been a couple of previous constitutional crises in Malaysia whereby the sultans have exercised a power under the constitution that they believe they have the discretion to exercise, but they exercise it against the advice of the elected government. And so this actually led to a couple of changes in the Malaysian constitution. I think in 1989 and 1992, the Malaysian constitution was changed, and they inserted a section, I forget the section number, it's around in the 40s, late 39 to 42, around there, where they said that if the constitution stipulates that a power needs to be exercised on advice, and advice is given, then the ruler will act on that advice. So you can see that political leadership was worried about the potential for the Malay sultans having this rival power to them. So they tried to constrain the Malay sultans. And I guess my other point was that the power, the political power, or the prerogative power of the sultans, or of the rulers, sorry, depends on whether they come from a state where they have a hereditary title, so the 9 states with hereditary sultans, or the 4 appointed state governors. What I'm saying is that I don't think they have very much independent power of the elected government. The state sultans do, on the other hand, and we only need to look back at this statement made around 1 week ago. And basically the statement, without saying it explicitly, impliedly asked the Prime Minister to stand down. So this may be seen as a encroachment upon party politics by the Sultans. Yes.
Have there been any proposed reforms as to the power of the federal Attorney General? Because it seems like in the PowerPoint that you showed us that the federal Attorney General does seem to have a lot of power.
Yeah. So I guess that there are a couple of problems with that, and remember that the two problems were that the federal Attorney General is also the prosecutor. So Malaysia happens not to be the only jurisdiction where you would get the prosecutor advising on pardon. And in Singapore, Michael, is that right? Does the prosecutor also advise on pardon? So I think any time you get a prosecutor advising whether or not to issue a pardon, they're unlikely to say yes, because they think, well, I've put all this effort into getting the conviction, why would we let him off now? Whether letting him off means having a lesser sentence or release from prison. So I guess one way to reform it would be to separate the institutions of prosecution with the advice role on the Pardons Board. So you wouldn't get the same person giving advice on prosecution and whether or not there should be a pardon. The second problem, what was the second part of your question?
I guess how do you,
Sorry, I was going to say the second problem is really that the Federal Attorney General is meant to be the state's legal advisor in Malaysia.
Right.
It's meant to be the state's legal advisor, but it's meant to be formally independent from the political executive. So I'm not sure whether any sort of legal reforms are necessary for that, but I mean, historically, there's been some allegations that the Federal Attorney General just does the bidding of the elected government. So the more you can separate the Attorney General from the elected, the political executive, then the more likely you are to get impartial advice, which is advice issued in the interest of justice, rather than advice issued in the interest of party politics. So I'm not sure how to do that, but that's the key crux of it, I think, to separate, to make the Federal Attorney General formally independent.
And is there any reason why as to this hasn't been done yet in Malaysia?
Why this hasn't been done yet? Well, I mean, Malaysia has a particularly strong executive. That's maybe the only reason I can think of. Malaysia has a particularly strong executive, and I guess they're still developing their democracy.
So,
Yep.
I just want to comment on that before I'm sure.
Sure.
I'm just reflecting on how this happens in Hong Kong.
Yeah.
And as I said before, for pardons, you petition to the chief executive.
Mm-hmm.
But there's actually a functional separation when it comes to the Secretary for Justice, and the Secretary for Justice is sort of the legal advisor to the executive.
Yeah.
And also the head of the Department of Justice, which handles prosecution.
But that is formally independent from party politics in Hong Kong.
Well, yes and no. I mean, the Secretary of Justice wears two hats in
Sure.
the sort of the traditional common law way, but functionally there's a separation. Whereas when it comes to prosecution decisions, they're normally left for the Director of Public Prosecutions, right? And then when the Chief Executive gets one of these petitions, what he would normally do is to get the Solicitor General to advise him. Now, the Solicitor General is on the same level as the Director of Public Prosecutions, but it's another branch of the Department of Justice. But at least there's a functional separation. So when you said that it's the same person, right? Well, in Hong Kong, it's the same person as Secretary for Justice, but it's functionally it's actually advice from a different department.
It could be a different person.
A different division.
Different division within the same department.
Within the department.
Yeah.
I wonder if that happens in Malaysia.
without getting into the Federal Attorney General's chambers, I'm not sure, but the Federal Attorney General does sometimes have a delegate on the pardons boards. So he tends to sit when it's a federal pardons case and give advice when it's a federal pardons case, but actually he delegates his responsibility to I think it's the Solicitor General.
So then it's not quite the same you can't say it's the prosecutor, right? Although it's all within
it's
the
within the
General's.
prosecutorial, it's within the prosecutorial office, I guess. But certainly at least in Anwar's case, I mean, the Federal Attorney General was the person who both prosecuted and appeared in court.
Oh, is that right?
Yeah.
I see.
And also the person who gave the advice
I see.
and sat on the pardons board. So
All right, I see.
Taylor was on the pardons board, so it was the same person. But I think you're right, in state cases, in state cases around Malaysia, it may be a delegate.
Yeah.
It may be a delegate, so it may be a different person.
Sure.
Yeah, I was really intrigued by the 2 points that you made in your first hypothesis, which
Okay.
are that factual innocence has never been a cause for pardon.
Yeah.
And therefore there's been no such thing as a wrongful conviction. But also the idea that a submission for pardon implicitly admits guilt by the individual concerned.
Mm.
And I wonder whether the system is set up to, essentially it's set up to force these applicants to fail, because there's no way that you can say I was wrongly convicted if you need to submit a petition.
Yeah.
I mean, if you don't have a family who's going to submit a petition on your behalf,
Yeah.
then essentially by saying I want a petition, I want a pardon, you're saying yes, I'm guilty. So you're kind of reminds me of kind of pleading the fifth, where you won't implicate yourself.
Yeah.
So it's kind of contradictory, and I wonder whether there's any way to get around that if you wanted to apply for a pardon, and how you would do that.
That's a good question. So, I mean, this is something I think Anwar wrestled with, and then eventually got his family to apply for the pardon on his behalf. And actually, it was also an issue for his first set of sodomy trials in 1998, where once he was convicted, he didn't want to apply for a pardon then either. I'm really talking about the second set of charges now, but for the first set of charges, he didn't want to apply for a pardon either. And then apparently a few of his supporters, his political supporters, submitted a pardon on his behalf because they knew he would be admitting guilt if he applied for the pardon. So yeah, one solution is to get someone else to apply for it on your behalf. Second solution is that, I mean, factual innocence is only one of the grounds, one of the potential grounds to apply for a pardon. And as I've said, it doesn't seem to have ever been successful in Malaysia. But there are lots of pardons that are issued in Malaysia, and in fact far more than the numbers in Singapore. I've done a comparison before. So in Malaysia, as I mentioned, there are non-legal factors. So your previous political service or your political connections seem to matter. Any retributive justification. So it's not so much. I guess you could say it's a miscarriage of justice, but it's not factual innocence. So any procedural problems in the trial, or the fact that you've argued self-defense, or you've argued duress, or some other sort of intoxication in the trial, but you haven't quite been able to satisfy that burden, then you can argue that there was some evidence or the defense in your petition. But you're still saying that you carried out the act. And then the third characteristic, if those fail, I guess you can go down the rehabilitation track. So you can say that, well, if I'm serving a life sentence or a natural life sentence, a whole of life term, then I've been in prison for 10 years and I'm a different person to the person who was convicted. So you have these other options, but I guess if your sole argument is that I didn't commit the crime, then you're best off asking someone else to apply on your behalf.
Does Malaysia have this mechanism that you see in other common law jurisdictions of ministerial reference, where the minister can refer the case back to the courts, even after you've exhausted all your appeal rights?
Oh, you mean the Attorney General's reference in the UK?
Not quite. That's a way of sort of appealing
Quasi
an issue. this is where you've exhausted all your appeal rights, but maybe there's new evidence to show that you're innocent,
Yeah.
and you can go to the minister to get the case back to the Court of Appeal. We have that in Hong Kong.
So that would be a judicial review in Malaysia. Judicial review.
But judicial review sounds like it starts from the lowest court again.
Yeah.
Whereas this would be something from the minister saying, hey, there's good reasons to look at this case again. And it goes usually to the Court of Appeal to look at it. I guess they don't have something like that.
I'm not sure. Michael, do you know about that?
No, not to my knowledge.
I don't think they have that. And in any way, the problem with that would be that it needs to start at in a political office rather than in an independent office.
Yes.
So the fact that it starts in a political office wouldn't help someone like Anwar, who's not very politically popular with the elected government.
But I was just thinking that if they had that separate mechanism, issues about innocence or guilt would be reserved for that route.
Yeah.
Whereas the pardons, it seems to presuppose that it's more forward-looking.
Yes.
And it accepts that you're guilty already, but yet there are reasons not to treat you like you're a typical offender.
Yeah. So, are you speaking about the Criminal Cases Review Commission? In the UK,
yes,
this sort of
like that.
Yeah.
But even in Hong Kong, we can go to the Minister of Justice, Secretary for Justice, to have the matter opened again.
Yeah.
It's sort of like your last resort, your last chance.
Yeah. Well, I guess that's one of the lessons maybe from Anwar's case, that you need a separate body to consider, or a separate mechanism at least, to consider factual innocence, because the applying for pardon, I mean, traditionally in the literature, this is seen as sort of begging the ruler for your life or your freedom, because you've repented and you have remorse over what you did. So yes, we need a separate mechanism.
Can I just follow up very quickly? How does this then impact on criminal records, and is there the possibility for records to be expunged or sealed in cases where, for example, you are granted a pardon?
Yes, the Pardons Board has the discretion to do that. So the Pardons Board can either release you from prison, or the Pardons Board can also sort of rehabilitate your record as well. So, I mean, if there were, how would that work if Anwar can't, if he has a ban from politics for 5 years, 5 years imprisonment, and then 5 years after imprisonment, and then let's say he were to get a pardon from the Federal Pardons Board, I think that's, I'm not quite sure, but I think that's up to the discretion of the pardons or the ruler. The ruler can grant a sort of free pardon, an absolute pardon, or the ruler can say, we're going to get rid of the punishment, but you're still, your conviction still stands.
Right, but there's the possibility for it to be expunged totally.
Yeah, I think
So
so.
never
I'm not quite sure on that, but I think they have that discretion. Yeah.
Okay.
Anyone else?
There are 3 lay members of the parole board.
Yes.
How are they selected? Are they the same people all the time? Do they rotate? Do they have term limits?
Yeah. So they're persons who are appointed under the Constitution by the Federal Attorney General. So this is the problem. They tend to be. Well, I think the original purpose behind this provision in Malaysia's Constitution was to keep a racial balance on the Pardons Board. So you were meant to have one Malay member, one Chinese member, and one Indian member. This was the original purpose. I'm not sure in practice if that happens or not. I haven't done a study looking at all of the lay members, and in fact their identities appear to be kept secret, possibly so that there are no consequences for their service on the Pardons Board. But what you do tend to find is when people retire from public life, or actually when people pass away, you will see in their obituaries, well, such and such was a member of the Selangor Pardons Board for 20 years. So they tend to already be quite senior people by the time they're appointed, let's say former public servants or former business people, etc. But also I suspect that the very appointment process makes it likely that they're more sympathetic to the government.
All right, so if there's no more questions, Daniel, thank you very much. It's been a very engaging and interesting seminar, and I wish you all the best for your work. Please join me in thanking our speaker.